Okay. Mentioned.
No, man. Judgment.
Oh, huh. Okay. The shifting of jurisdiction. Mr. Lambo, sorry, we had to go against you. Petition is dismissed.
Like
Yes.
Please, my lord. My lord, I may be allowed to move an unlisted LA appeal, my lord. Since it's a connected...
LA appeal?
Yes, my lord. Connected matter, my lord, it is... Today it's listed at item 15.
So what happened in your India has already filed. That's item number 15.
15, my lord.
So let it be tagged there.
Okay, there is a matter here.
Yes,
Similar matter.
already similar.
Okay. Connected.
Connected.
You're on a similar matter.
What are the IAs for? This new IAs for? These are LA appeals or IAs?
No, you're on this LA appeal.
LA appeal.
Appeal, man.
Okay.
Your Lordship, I beg to mention item number 2.
Wait.
Item number 2.
Wait.
Your Lordship, earlier this matter was refused to take up by this honorable court. So therefore, we have mentioned before the court number 1 for to take up. Therefore,
I refused.
Lordship, the same case of the this court number 1 should be taken up, Lordship.
Before the appropriate bench, which had considered similar, which had considered bail applications arising from the
Same FIR.
same FIR. Sorry, that matter. Yes. Anything more mentioned? No. Should agree.
Lordship.
Wait, anticipatory bail application. I'll just read the FIR matter. Page 12.
What role did you have to make this phone call?
My lord, though the FIR reads in this manner, my lord, what it's difficult for me to say now, but it was they had, my lord, accepted to donate for the Solong festival. It was in that context.
The other accused have been
They are not named. They are item number 5, 6, and 7.
four is different.
4 is different.
Yes,
Extortion abductions.
you get your CD. We'll
Yes,
just take
this
it back.
item number 3 is a name accused in FIR, and 5, 6, and 7
Okay.
are not named.
Named, but if they are connected or not, you get the CD. It's from. Get a scan copy
Yes, from
Roxin,
tomorrow.
Papasiga.
Tomorrow,
Tomorrow, will not be possible.
scan copy. How much time will it take? Your CD must not have become so much. Starting only
Yes, day after. Oh,
Monday.
Monday.
The present application has been filed, praying for pre-arrest bail in connection with Ruskin PS case number 14/2024 under section 308 bracketed 2/140 bracketed 3/3 bracketed 5 of BNS 2023. So issue notice. Heard Mr. Deepaning and Mr. Tarup Ligdano. Issue notice. Call for the case diary. List the matter again on 23/12/2024 for production of a scanned copy of the case diary. We'll see and then pass. Same order in item number
5, 6, 7.
5.
Can we be protected till 23 so that you can give a statement?
I can't pass a no coercive order. Let us see, because there is a clear. We understand you may have a case, but let us see what is there. 2, 5, 6, 7, same order.
No, 3, 5.
3, 5, 6, 7.
3, 5.
3, 5,
6 and
6, 7. Separate order, Mariega. All on 23.
Okay.
Only one court on that day, he'll have much problem, that means. Yes, Mr.
But this is also pre-arrest bail. Well, FIR is
Page number 25.
Is there a cross FIR here?
Yes, my lord. The same has been also registered, my lord.
By the victim?
Yes, by the victim
Okay.
and complainant attorney.
You appear.
Yes, ma'am.
Heard, Mr.
M. Doji, ma'am.
M. Doji, Learned Counsel for the. Yes, madam. Let him appear. Let her appear.
Yes.
I think it seems to be some misunderstanding. You are appearing for.
For the informant.
You have taken bail.
No, for the informant.
Against you also there is a FIR.
Yeah.
You have taken bail.
No, ma'am.
Heard Mr. So and so, Learned Counsel for the petitioner. Also, applicant also heard Ms. T. Jing, Learned Additional Public Prosecutor, appearing for the state respondents, and Ms. Your name?
P. Borang.
P. Bora, assisting, appearing for the informant, assisting the Learned Additional PP. Full stop. The present application has been instituted, praying for pre-arrest bail to the accused, Mrs. Rekha Sonam, in connection with Papu Hill case number 102/2024. Under section, यहाँ से page 2 में है, under section देख लीजिएगा. So and so. Issue notice, call for the case diary of the above noted police case, along with the case diary. What is the other case number?
103, ma'am.
Along with the case diary of
Same police station.
Same police station, Papu Hill Police Station, case number 103/2024, under section 103/2024. Full stop. Having considered the submissions advanced by the petitioners and also on perusal of the materials brought on the court, this court is of the view that the petitioner, in the event of arrest, be enlarged on pre-arrest interim bail of on filing a bond of rupees 10,000 with 2 local surety of like amount to the satisfaction of the arresting authority, subject to the following conditions. 1, the petitioner shall appear before the investigating officer in Papu Hill, in the above noted, in Papu Hill Police Station, case number 102/2024, and her statement on or before. Today is 19th.
Yes,
On or before 27/12/2024. Full stop. बाकी वो influence नहीं करेगा, वो सब लगा दीजिएगा. And list this matter again on 7/1/2025 for production of the case diaries in the above noted 2 police cases. Yes, Mr. Tara.
Well, initially, when I was laying my hands on this brief, I thought it was a simple case of disputed question of fact. But when I deeper into the fact, then I came to know that there is an executive magistrate order, which that order is still in force, that has not been put into challenge.
But where is that? It's not here.
It is here in my petition, my lord. I kindly come to page 37, my lord.
It's not a order challenged.
Yeah, this order is not challenged, my lord. So therefore, any subsequent proceedings the Learned Deputy Commissioner tried to conduct per se is barred by the.
Yes, who is appearing?
The respondent
And
then, my lord, I will have to place, my lord, kindly allow me to refer to the act. Once you, Lord, see, we read the act.
why was it adjourned the last date?
Well, I did not lay my hand, it came because of some consecutively 7 items on that day in this court.
That gifted.
My lord.
No, my lord, I will explain before my brother.
Yes.
My lord, a valid allotment order is there, my lord, which was cancelled without the.
Without hearing, yes. What do you say?
No, my lord.
Tadum.
No, my lord, I'll demonstrate, my lord.
No, Mr. Here we are considering
Kindly come to
order
page
passed
61.
against,
Kindly come to page 61. The question which my lord has raised, that he has not been given fair opportunity of being heard. Kindly come to page 61, Lord, straight.
this complaint at page 58 was filed by you
Yes,
against him. Page 60,
61.
61.
My lord, I'll read the para 1, 2, 3, 4 para that on perusal of records, it is reveals that several date, I think a mistake is there. That on perusal of record, it is reveals that several dates were fixed for hearing why dated so and so, so and so, so and so, so and so, despite receipt of order. My lord will mark this. Despite receipt of order, the opposite party, Sri so and so.
The records
never
have come. Records have come.
Records.
Records again. Yeah, right.
One number 2 is not denied by the.
No. From where do you justify this? Where are these orders?
This is,
Are these orders on record?
yes.
No. This orders of
Which
they
one?
passed on 10-2, 22-2, 3-3, 10-3, just to show that how this notice was held to be served. on
Annex
you.
10. Kindly come to page, no, Annex 10.
Okay.
You received notice.
No, man.
No.
They should be able to produce a number.
Because this is,
Post
this
report.
is a order passed by a quasi judicial authority.
Fine.
Therefore,
But his plea is, I think there is a ground in the affidavit also.
correct.
Government affidavits, paragraph 14.
Where is that?
And this is supported by government affidavit paragraph 14. Kindly have this government affidavit for a moment. Page, just find out.
Paragraph 14, page number. Government affidavit. If government also, my lord, is on their side, they should be able to adduce, my lord, the record of AD card or even post receipt, my lord, of issuing someone to.
No, where is that police statement? Annex 4. Madam, madam, kindly come to page
This
9.
land was of somebody that was by way of a gift deed, he says he has entered into it. Then the
Madam,
LPC was issued, which you challenged, was cancelled. Now, just show me, before we start off, that a notice was received by him.
Kindly come to page 9 of government affidavit.
Page 9.
Yes. Bereft of this page 61 statement or order recorded by the
Where?
page 9.
Para 14.
Para
and
14. That with regards to the statement ever been made in paragraph 14.
No, this is just a repetition of that orders.
Yes.
But where is that statement that notice was received by? Here it says notice was issued.
Well, it is here only. Kindly, just I'll 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12,
Okay.
13, 14.
Despite being received, despite
Yes.
of receiving the order, concern so and so has been served on the same on so and so has failed to turn. Yes. You were.
If at all, my lord, at least someone on notice issued, my lord, then they should be able to.
There is a police report to that effect
26, page 26 of this report is there in page 26.
of the affidavit.
Affidavit. Annexation A. Correct?
Padung served.
So,
And there is respondent number.
Where is your statement? Respond number 3, 4. Your 4.
For 3 and 4.
3 and 4 both.
Okay. This statement is also there.
In
Para 7.
any case, he is only an encroacher, my lord. He has no locus in the event, my lord.
Why did you not approach? Why did you not appear?
Yeah.
He will not serve with any notice.
That cannot be accepted in view of this. Where is your statement in the affidavit that notices were not served on you?
Where is that? No, it's not there.
At page 7 of my affidavit, my lord, para 11.
Which affidavit? There are 2 affidavits.
May I read, my lord? for the respondent number 3, my lord.
Okay. Para?
Para 11, my lord. My lord, that in regard to averments made in para 13 of the writ petition, the deponent strongly denies and contends that he ever received any summon or order issued by the Deputy Commissioner, Itanagar Capital Region, or by the officer in charge Itanagar Police Station, and as such passing of any order after examination of all relevant documents does not
Okay.
arise.
Where is this? This is the only ground you have that you were heard without hearing you, they had passed this order. Mr. Tara, is the police report we have seen, but is the notice that was received by him, his signature, brought on record?
Madam,
His signed copy of the receipt book?
this is police report.
Hmm?
This is police, police has served the summons.
Fine.
Affected, because.
Fine. The police will serve, will take a signature, will not just go and throw it and come back.
Well, that,
Police can be mentioned.
Records, hearing records of the order. It's with you.
No, my lord.
Get that. So, Mr. Tara, if that is the only thing, we'll examine if it is there, if he has received
No,
it. That's the end of the matter.
well, that is not the end of the matter. The larger question is, the order that is passed, or the fact, let me throw in 2 minutes, Milord.
We'll hear it after when it is called to be heard. We'll get the things cleared first. Let the preliminary objection be cleared first. Heard Mr. T.T. Tara, learned counsel for the petitioner. Also heard Ms. So-and-so, learned counsel appearing for the state respondents, and Mr. So-and-so appearing for the respondents number 3 and 4. The learned counsel for the respondent number 3 and 4 at the outset had raised a preliminary issue to the effect that the notices in the case, notices of the hearing of the, what was the case number, Mr. Tara? In case number DC-ICC-12016/7/2021 was not received by him. Full stop. However, the said statement is disputed by both the learned counsel for the petitioner and the learned counsel representing the state respondents. Full stop. In order to ascertain the issue, said issue, Ms. So-and-so learned counsel appearing for the state respondents, learned comment advocate, shall produce the records of the above noted case from the office of the Deputy Commissioner Itanagar, along with the documents envisaging the service of notice upon the respondent number 3 and 4 hearing. 4 hearing. Registered to list this matter. Madam, how long will it take? It's here only.
Yes. After
Tomorrow?
vacation.
Tomorrow?
Tomorrow will be possible. After
Then let
vacation,
us
your
have it
worship.
after vacations.
After vacation.
On 8th.
No, Milord, 8,
You have some problem? 9th, Mr. Tara?
no, 9th and 10th, that the matter comes.
15.
15, that's fine.
15, madam.
Interim order is there.
Interim order passed earlier to continue till the next date of this.
Grateful, Milord.
No, like.
Let us redress that first.
Otherwise, on.
Otherwise, it's gone. Yes,
My lord,
you are from the opposite side today.
my lord, here, I'm challenging the impugn order dated 12th July 2023, my lord, whereby despite having sufficient material for framing charge under section 202, my lord, the learned trial court has framed the charge under section 306, my lord. Although charge sheet has been filed under 302, and there's ample material, my lord. And
Order was passed after examining the materials, my lord. So, the roasting will to examine all the time.
I'll have to, because this order does not even indicate what was the materials relied upon for this
So
purpose.
maybe if the paper book is to be prepared.
No need a paper book. The original records are here. We'll proceed as We'll fix it after the vacations. This matter will have to be considered. heard the learning council for the parties. सबका नाम लिख लीजिएगा. So, the case is ready for hearing. Accordingly, the same criminal petition is admitted. Registry to list this matter again on. We'll have it towards the end of January on 21/1/2025 for hearing.
Deeply obliged.
But the order,
Yes,
nothing is.
that is the difficult.
My lord, they are on material, my lord. The entire charge.
What were the material he
Yes,
considered?
it is
At
not
least
there.
that much.
It is not reflected.
For me.
It should have been reflected.
Exactly,
If these are the circumstances. Okay, fine.
That is my lord. That's why.
That's the requirement, basically.
I was there, I recall, my lord. Deliberation, the learned trial judge, of course, in gave.
But I think
this.
this is the earlier two cases I had dealt with.
Well,
One I disposed of.
Well,
Therein it was highlighted
Yes,
that
ma'am.
these are the circumstances which you were there, so yes. These are the circumstances. I had a real tough time with that. These are the circumstances which led me to discharge her.
my lord.
Beautiful. So we only had to deal with that. Yeah.
Nothing. That's why.
The whole record will have to be.
Anyway, we will see.
Right. Deeply obliged.
Ma'am,
Yes.
so this is an statutory appeal under section 74.
Hmm.
We can exactly.
We will have to issue we'll admit it.
Admit, ma'am, Lord, and your lordship will call for the records of the reference case as well as, Lord, the collector's record with regard to the acquisition.
This is from Alo. Passed by the district judge. Alo.
But
Right.
actually, KCO.
Huh?
Siomi. District is Siomi.
Just write it down. The present appeal has been instituted invoking the provisions of section 74 of the right to fair compensation, transparency in land acquisition, rehabilitation and resettlement act 2013. Heard Mr. K. Agarwal, learned counsel, assisted by Mr. D. Senapati, learned counsel appearing for the appellants, and Mr. P. Pathak, learned counsel appearing for the Pathak, you are appearing for?
Landowner. One to 71.
For the respondents number 1 to 71. Mr. Ratan, you are also appearing?
Yes, for 72.
And Mr. N. Ratan, Additional Advocate General, Arunachal Pradesh, appearing for respondent number 72.
We have served the copy.
Full stop. As the parties have, as all the respondents are represented, no formal notice is required to be so issued. However, requisite extra copies of the appeal be furnished to the learned counsel for the respondents. I have used requisite. If he wants one, he can give you one also.
I don't want 71. Ask for a soft copy only.
Soft copy will give.
I will be requiring one.
One. Well,
We'll give.
That's why I did not use as many copies. I used the word requisite. Full stop. Admit the appeal. Full stop. Admit the appeal. Admit the appeal. Full stop. Next paragraph. Registry to requisition the records of the whatever records you want, Mr. Senapati, just put it out from the court of the so and so. Registry to list this matters again after 4 weeks on a date 4 weeks. Mr. Kamal, both of you.
Fixed on 20th, not
20th of January. Okay. On 21, full stop. Registry to list this matter again after 3 weeks. Full stop. As agreed to by the learning council for the parties, registry to list this matter again on 21/201/2025.
My career may be good.
Full stop. Caveat, huh? So and so. Order the hai? Mar dijiye. Discharge.
file an application for the staying of the operation of the interim judgment and order. Okay.
I heard same. Issue notice. returnable on
That
20,
same date.
21, 2025. Full stop. The respondents are at liberty to bring on record their objection to the prayer made in the interlocutory application before the next date of listing with an advance copy to the learned counsel for the appellants. ऊपर में खाली एक paragraph लिख दीजिएगा. The present interlocutory application has been instituted, praying for keeping in abeyance the judgment and order dated 17/10/2024, passed by the learned district judge, accusation, rehabilitation, and resettlement authority, ALO, Arunachal Pradesh, in ALO reference case number 02/2024. उसके बाद issue notice.
In the meantime, till then will not do it. Till then will not their lordship will keep in abeyance.
No. We will hear. Let us hear it. Land acquisition matters are very touchy. Let them have their opportunity. Some authority has already decided.
Because what happened, my lord?
Because see, if I have to do that, I'll have to go into that. I'll have to examine that. Let on 20th we will do that.
I have to understand.
20th the hearing is not going to take place. That is why I said before that date, at least you can take up the prayer. The prayer so made in the interlocutory application shall be considered on 21/2025 after the affidavits are so filed in the matter by the respondents. Here you'll be going back. Going back or here?
Going.
It's nice. कागज में लिख के दे देगा. You just give it, Mrs.
Yes, that.
मैंने से इसको लगा तो गर्मी हो गई. थोड़ा सा.
Your Lordship, here in this matter, Your Lordship, there is a stay, and because of that, Your Lordship, the FOXO investigation cannot be proceed further because of the stay order, Your Lordship. And that was passed in the month of February, Your Lordship. So now, Your Lordship, according to me, there is a settled law, Your Lordship, basing on which the stay was granted, Your Lordship. It is well settled now, Your Lordship. That initially, Your Lordship, here in this case, what has happened, the lady has lodged an FIR. That was not registered, and subsequently again he made an application before the SP concerned, and it was again not registered. Now then she filed an application under section 200 of the complaint. If I see filed a complaint, her deposition has been recorded, and then basing on the deposition, the learned special court has directed the investigation agency to investigate the matter. So now here, Your Lordship, the only issue was that whether after recording of the statement deposition under 200 on oath, that will be considered as a cognizance taken by the court or not. But according to the Your Lordship, I have the law citations which says no. The statement has been recorded for the purpose of taking cognizance.
Para 12 of that 2015 9 SSC.
Yes, Your Lordship, I have the judgment here, Your Lordship.
Just give the citation.
Yes, Your Lordship. Your Lordship, Your Lordship, initially this issue was raised in 1951 SCC 250. And then, Your Lordship, again it was come in 2015 9 SCC 609.
9 SSC, para 12 and para 12 it says that the cognizance means taking notice of the accusation applying.
Yes, Your Lordship.
It is neither practicable so and so to what is meant by taking particular case.
Yes.
Then what was the conclusion here?
Your Lordship, in RR Chari case, Your Lordship, I have the judgment. Your Lordship, although the petitioner is not here, Your Lordship, but the law is well settled. Para 16 per Your Lordship, may kindly seek.
But the learned counsel is not here.
Morning, Your Lordship, he was here. Perhaps he's in.
Put number 1.
Yes, Your Lordship.
Who is appearing?
This for the victim side is appearing.
Victim side, Your Honor. I have exhausted all the remedies. And in fact, I have filed in the CR
Okay.
case also.
Para 15, what is it there? Gopal Marwari. Para 15.
Yes, para 16, Your Lordship.
16.
I will start from 16, Your Lordship. After referring to the observation in Emperor versus Soindra Mohan Chakrabarti, it was stated by Das Gupta, Justice in SUPD and Remembrance of Legal Affairs and Avini Kumar Banerjee as followed. What is taking cognizance has not been defined in the Criminal Procedure Code, and I have no desire now to attempt to define it. it seems to me clear, however, that before it can be said that any magistrate has taken cognizance of any offense under section 191A CRPC, he must not only have applied his mind to the content of the petition, but he must have done so for the purpose of proceeding in a particular way, as indicated in subsequent proceeding of this chapter. Chapter proceeding under section 200 and thereafter sending it for inquiry and report under section 202. Now this is, your lordship, this may be noted. When the magistrate apply his mind, not for the purpose of proceeding under subsequent section of this chapter, but for taking action of some other kind, that is ordering investigation under section 156(3) or issuing a search warrant for the purpose of the investigation, he cannot be said to have taken cognizance of the offense. In our opinion, this is the correct approach of the question before this court. So now, your lordship, here what has happened, 200...
This case is that the complaint having been, the statement having been recorded.
Yes.
Deposition having been taken. So satisfied. So it should be the complaint that should proceed.
According to them.
And not the
investigation. Yes, your lordship.
Have been sent for investigation.
Yes, your lordship. To that, your lordship, effect, I have one judgment where it says merely recording of the deposition under 200 of the CRPC, your lordship, will not amounting to taking cognizance. That is only for the purpose of taking cognizance. Now, at that point of time, if magistrate decide to proceed with the subsequent procedure of chapter 15, then only the magistrate, your lordship, the subsequent provision of the complaint case has to be followed. Otherwise, it is for the purpose of investigation, then it cannot be said that magistrate has taken cognizance, your lordship. Because once cognizance has been taken, then magistrate cannot direct for investigation. That is the law. Yeah.
So when the case is at the stage of 200 and not proceeded further to 202 and 203,
yes.
Then it's fine.
Yes, your lordship.
Investigation can be done.
Yes, can be done.
But once you approach 202 and 203,
yes,
then it should continue as a complaint.
Yes, your lordship.
Okay, then
now, your lordship, the second part, your lordship, regarding whether statement recording under 200 would be amounting to taking cognizance or not.
I have this.
Okay, your lordship, in para 8 and 14, your lordship, para 8, your lordship will kindly find your para 8. Whether the statement recording under 200 is amounting to taking cognizance or not, that has been decided here. Section 200 CRPC provide for the procedure for the magistrate taking cognizance of an offense on complaint. The magistrate is not bound to take cognizance of an offense merely because a complaint has been filed before him, when in fact the complaint does not disclose a cause of action. The language in section 200 CRPC, a magistrate taking cognizance of an offense on complaint shall examine upon oath the complainant and the witness present, if any. Clear suggests that for taking cognizance of an offense on complaint, the court shall examine the complaint upon oath. The object of examination of the complainant is to find out whether the complaint is justifiable or is vexatious. Merely because the complaint has examined, that does not mean that magistrate has taken cognizance of the offense. Now, this is very clear, your lordship. Meaning thereby, the cognizance has not been taken. There is a thin line, your lordship. Taking cognizance of an offense means the magistrate must judicially apply his mind to the content of the complaint and indicate that the magistrate has judicial notice of an offense. Now, your lordship, even for the purpose of investigation, the magistrate has to apply his judicial mind, your lordship. He cannot direct mechanically, your lordship.
Come to para 11.
Yes, your lordship. Section 200 CRPC contemplates a magistrate taking cognizance of an offense on complaint to examine the complaint and examine upon oath the complainant and the witness present, if any. Then normally 3 courts are available to the magistrate. The magistrate can either issue summon to the accused or order an inquiry under 202 or dismiss the complaint under 203 CRPC. Upon consideration of the statement of the complainant and the material adduced at the stage, if magistrate is satisfied that there are sufficient ground to proceed, he can proceed to issue process under 204. Section 202 CRPC contemplated postponement of issue of process. It provides that the magistrate on receipt of the complaint of an issue of which he is authorized to take cognizance may, if he think fit, postpone the issue of process for compelling the attendance of the person complained against and either inquiry into case himself or have an inquiry made by magistrate subordinate to him or an investigation made by a police officer or by some other person for the purpose of deciding whether or not there is a sufficient ground for proceeding. If the magistrate find no sufficient ground for proceeding, he can dismiss the complaint by recording briefly and reason to doing so and contemplate under 203 CRPC. A magistrate take cognizance of an offense when he decides to proceed against the person accused of having committed offense, and that offense, and not the time when the magistrate is just informed either by complaint, by filing complaint, or by police report about the commission of the offense. Now, Your Lordship may come to 14, Your Lordship. Here, Your Lordship, this procedure 11 is contemplated regarding, Your Lordship, procedure for
Read 12 also. Cognizance.
cognizance.
As a reference.
There has been reference to the application of judicial mind by magistrate in connection with the commission of an offense, and not merely to magistrate learn that some offense has been committed. Only upon examination of complaint, the magistrate will proceed to apply the judicial mind. Now here says, Your Lordship, it's very clear.
Whether-
Only examination of the complainant, the magistrate will proceed to apply. After that, Your Lordship, the cognizance part come. At that point of time, the magistrate will decide whether to take cognizance or give direction for registration of FIR. Here is this distinction. Your Lordship.
Read the next.
When the,
Under.
when the complaint is examined, the magistrate cannot be said to have ipso facto has taken cognizance. When the magistrate is merely gathering the material on basis of he will decide whether a prima facie case is made out for taking cognizance of the offense or not. Cognizance of offense means taking notice of the accusation and apply the judicial mind to the content of the complaint and the material filed therewith. It is neither practicable nor desirable to define as to what is meant by taking cognizance. Whether the magistrate has taken cognizance of the offense or not will depend upon the facts and circumstances of the particular case. Now, Your Lordship may come to para 14, Your Lordship. A 3-bench judge in this court in RR Chari, yes, I've referred earlier, while considering that case, taking cognizance means approve the decision of the Calcutta High Court in Superintendent and Remembrance of Legal Affairs versus Abani Kumar Banerjee, wherein it was observed that what is taking cognizance has not been defined in the Criminal Procedure Code, and I have no desire now to attempt to define. Yes. Here, Your Lordship said it is the court has to consider for what purpose magistrate apply his mind. For taking cognizance.
Judgment. Any more judgment?
Yes, Your Lordship. Lordship, the citation is 2013 6 SCC 384. 384, Your Lordship. Here it says, Your Lordship, when complaint is filed, then magistrate can even consider that complaint into an application for registration of FIR.
FIR.
Yes. In para 40, Your Lordship.
Para?
40, Your Lordship. 40.
40.
Yes.
Okay. Show me the order.
Lordship, may kindly come to page number
17-1, page 16.
16, yes, Lordship. Here, Your Lordship, the fact is written in the second para. It is submitted by the learned counsel for the competent that the complaint has filed an FIR before OCPS on so and so, which received by OCPS SEPA but has not been registered by any case, and the accused is not arrested and no investigation has taken place. It is submitted that on 5/1/24, the complainant has also filed an application before the SP SEPA regarding non-registration of FIR by OC SEPA. But even after such complaint, the FIR filed by the complainant is not yet registered and no investigation is taken place. Being agreed by the action of the East Coming Police present, complaint is initiated before this court, praying for direction to be issued against OCPS SEPA for registration of case and proper investigation. I have perused the record of the present complaint and observed the statement of complainant. Statement is recorded. It's already recorded on oath under section 200 of CRPC. It is alleged that by the complainant during the year in so and so, she was a student of class 11 at Government Higher Secondary School and her age was 17 years. Accused in present case, namely Ika Rimo, is related to her brother-in-law. During last part of 18, one day, she along with Mrs. So and so came from Nal Lagan to our SEPA on the vehicle of so and so. They have stayed at residence of so and so. Here, she has not perhaps given the explanation why so much delay. It is alleged that she was agreed with him and she was not ready for any so and so, but he was succeeded to fulfill his evil desire and committed forceful sexual intercourse with her. Thereafter, wife of so and so came there and her family members also arrived there. The accused has promised her that he will marry her as second wife, and her family has also agreed, for which she has married with so and so as second wife. Thereafter, Ikarimo started mentally as well as physically torturing her and even assault her with pistol and revolver on her forehead, for which she has sustained injury on her face. Ikarimo used to abuse her with unparliamentary word and physical assault her by slapping, punch and threatening. He even assaulted her by strangulating her neck and threatening with dire consequences. now so and so has even not even look after her and torturing her with false allegation. In this regard, she has
But
filed.
she then went back and was staying with the accused as his second wife.
Yes, Your Lordship.
Then what happened? What triggered of the problem? Because if the 2018 thing was resolved, and what triggered of again 2022 to file this FIR?
The differences, Your Lordship.
Yes, yes. What do you say?
May Your Lordship.
What is the reason for your delay? Because you went back and stayed with him as a second wife.
At that time, I was minor, Your Honor. Your
Okay,
Lordship.
fine. Forget it.
So,
You became
for
when
taking
you
this
went-
decision,
When you became major,
Yes.
you were already his wife.
yes,
Then you stayed with him for around 2-3 years.
because of some family negotiation, I
Okay.
was forced to stay with him as a second wife. But
Where
later
is
on,
that?
he started,
Where is that allegation?
in that regards, I have filed an divorce petition at Bomdila also. Bomdila.
What is
he
the
was
ground
not,
taken? What is the ground taken? That you were forcefully put there.
I have reflected in my FIR to the superintendent, that is page number 31.
Just to. LBC. This complaint case was closed on transfer. It is pending.
I think, Your Lordship, this here in the complaint case direction was given to register the FIR. Your Lordship, coming together.
That I found.
That was stayed, Your Lordship, by the Honorable. Investigation has been stayed.
Where is that FIR? Page?
Page 31 is the first, page 32 is the first FIR that I've filed in the office, police station SEPA, page 32 of their petition.
Page 30?
32. This is the FIR that I've filed at of police station SEPA. Thereafter, no FIR was registered. Therefore, I lost a
Mr. Ate, have you seen the FIR? The first FIR filed. This is not basically against the incident of 2018. This is basically against the torture after marriage.
Your Lordship, but the fact remains same, Your Lordship, that which judgment has been quoted and quoted also, Your Lordship, the Independent Tone versus Union of India, Your Lordship. There it says, even if the minor is entered into marriage.
That will not.
Yes.
That is.
That is one of the aspect, Your Lordship.
Yes, Mr. Tofan. What is your?
Sorry, my lord.
No, it's okay.
My lord, the legal position that has been raised, but I'm not disputing at all those two after the recording of statement of the
victim, but then magistrate doesn't proceed, my lord. It's up to the magistrate to proceed further or not. But what the law says is, lordship, once the magistrate has taken cognizance of an offence, he cannot direct the police to investigate. Man. That is the law, man. And my brother has correctly pointed out, but he is aware that magistrate need not take cognizance of. I admit to that, but it's not necessary that magistrate should take cognizance. Now, this is a case, malab, where the wife, husband and wife, malab, if lordship will see all the affair, it's written the wife of Ekarimo, if lordship will kindly see all this too. And if lordship kindly peruse
But the court has not expressly taken cognizance. It has only said.
No, that's why lordship,
POSCO Act, the POSCO Act.
Page 19, malab, if lordship
19.
sees the order of the learned court
19.
below. Yes, page 19 starts.
Second last paragraph.
Yes, malab. Malab, it says, describes everything, malab. Let's say, Honorable High Court in Judgment Division Bench consists of Justice such and such, such and such, such and such, malab. Lordship will see the further paragraphs in page 18 also. Lordship is the vividly described what offense has been constituted.
33, your lordship.
30?
33, procedure and power of special court.
33. This book, section 30 is wrong. A special court may take cognizance of any offence without the accused being committed to it for trial upon receiving a complaint. So and so, so and so. Special
Yes.
court is the case.
This provision was quoted.
Accordingly, communicate the questions to be put to the special which shall.
Your lordship, if we read the paragraphs in page 17 and 18 also, Lord.
Just a minute. So here it says that cognizance is permissible both on a complaint receipt and as well as on a police report.
Yes, your lordship.
But it does not say anything further.
Yes, your lordship.
Then the provisions of CRPC was made applicable.
Yes.
Section 31.
Yes, your lordship.
Okay.
It is the, your lordship, discretion of the magistrate.
Yes. This.
No, man, if you lordship will kindly see page 17 onwards. If you no, but it had to, I don't want to read the lines, but the learned court below is the vividly described what kind of offense has been committed. My lordship, last two
This we will say, that these are all tentative.
No.
For the purpose of arriving at a satisfaction as to the complaint is correct or not.
The law is very clear.
And he has not said anything further. He has only said that the offense has to be investigated. He has not said that, because naturally when the date of birth of the petitioner of the victim was before him, it was found that she is a child on the date of commission of the offense.
Yes.
So in that view of the matter, POSCO was attracted. Plus, there is another episode of her marriage and a torture, 498A. So he had, without saying anything further, remanded the matter to the, sent the matter to the police, and see now, a charge sheet is being directed to be filed here upon investigation, 173, final form.
Yeah.
So then, and it is only monitoring the investigation.
I may be wrong, my lord, but to my humble understanding, my lord, what the magistrate learned court has done is that he has described what kind of offense has been committed by the accused person in the entire description. When the learned court
we will clarify.
Has described that means, my lord,
we will clarify that, Mr. Tafo.
Yes.
He has only brought on record the disclosure made in the FIR and what the statement the victim had done.
Yes, my lord.
You challenge it on the ground of delay, you challenge it on the other grounds, but on this ground, maybe the Supreme Court decisions. You have any decision?
Yes, I have last
23.
Sorry, man.
Yeah, it's here.
I have already, yes, 2023
23.
SC online S5.
Kailash Vijay Grevia.
Yes, ma'am.
What is here?
Lordship, I'll just relevant portion of the.
Hmm.
It starts from page 8, para 81.
Was those two judgments also taken considered here?
Well, this has taken consideration many of the cases, Lalita Kumari and others and all those aspects.
No,
also.
no, the decisions,
So,
Mr.
Here, Malad,
Ete has referred 2015-9,
In 1951, Your Lordship, it's a full bench judgment, Your Lordship.
1951.
Yes, ultimately it has been
Lordship,
reiterated.
but-
Your Lordship.
Okay, you show me para 81.
Yes, ma'am.
Court of Judicature of so and so.
So, when I'm submitting is Malad, that's same. Malad. In my opinion, Malad, magistrate has taken cognizance, Malad, by reading the paragraph, because he has dealt with the merit of the statement which has been made before the learned court below. Malad. Basing on that, Malad, he has described that POCSO attracts, Malad. That means he has taken the cognizance.
POSCO attracts is a natural corollary from the age of the victim as on the date of the offense.
Madam, the procedure is once after recording the statement of the victim and the witnesses complainant, madam, the procedure was simply to direct the police to register a case, madam. That is the method, madam, without describing anything, madam.
POSCO court, maybe she was exercising powers under section 33, the powers given to her. So she has gone to that extent. But whether it can be said that she had proceeded further to 204, etc., that stage did not come.
That stage has not come, I admit to that, but whether the cognizance has been taken or what, that is the good question in this case, madam. Once he is taken judicial notice, but it cannot be sent to the police.
So your case is 156(3).
Yes.
Should have been utilized and the matter should have been sent.
It should not have described anything, madam. Simply should have directed the police to register case and investigate. Whereas the lordship has already seen the detailed order has been passed. Detailed order means magistrate already taken cognizance what kind of offense has been committed. Now also it's not, the learned court bill is not precluded from taking assistant of police at this stage.
202.
Yes. Take the assistant of police, madam, but cannot direct the police to register a case. Otherwise, it will happen with two times cognizance will be taken.
No, here cognizance has not been taken.
Judicial notice,
Judicial notice by itself.
Judicial notice.
There are decisions Mr. Atta has placed. Mere examination of a complainant will not.
No, I admit to that, but it's not mere examination. It's vividly described what kind of.
Vividly description, it's writing orders in the order, bringing on record what is there in the FIR.
That's what Supreme
What
Court
she
said.
has said. Show me that.
What the
Show me
judgments
that,
are placed, madam.
that only by narrating the facts in the order, it would tantamount to a cognizance being taken. Just give me a decision on that.
Simple, madam.
She could have done it simply.
Yes.
She ought not to have proceeded on this. Use the power under 156(3).
Yes, madam. That's
Directed.
Yes,
that
madam.
go and register it.
Yes, madam.
Finished.
Yes.
But she was acting also under a special act.
Yes.
Section 33 empowers her to take, or the court to take cognizance on a complaint being made.
Yes.
So maybe there was a slight approach error in describing actually, but she has not done. She has not, the learned trial court has not taken cognizance here.
I leave to your lordship, madam. That's my humble understanding, madam.
If there is any other case, you can.
No, madam.
Was this a judgment under the POSCO Act? Vairagi? No. Okay, but if I have to close it, I'll have to examine the matter nicely. So orders will come only in the second week of, because I will not have my stenos also with me from tomorrow till 3rd. So thereafter only you will get the order.
Okay, Your Lordship.
Maybe.
Lordship, the factor is that, my lord, yeah, they were
Maybe.
husband and wife. And then when marriage broke down, my lord, then this case was filed.
Maybe we'll put it on 17th for delivery of orders.
Okay. Your
Yes.
Lordship.
Huh?
Okay.
I'll deliver it from there.
Okay.
You all come online.
Yes,
Okay.
Heard the parties at length. Also, Mr. Ete,
Yes, Your Lordship.
can you give me just a small 2-sheet note with all this
Okay, Your Lordship.
relevant? Don't quote the paragraph, just the relevant paragraphs you just mentioned.
Only paragraph.
Only paragraph.
Okay.
What deliberations today? 2-page or 3-page? Not
Okay.
that much only.
Okay, Your Lordship.
Heard the Lanaka. You, Mr. Taffa, you can also submit
Yes.
your note.
Yes.
But tomorrow,
Yes.
heard Mr. So-and-so Taffa, Lanaka Council for the petitioner. And also heard Mr. T. Lanet, additional public prosecutor appearing for the state respondent, and Mr. R. Rangsap Lanet, counsel representing the victim respondent number 2. Also, hearing concluded. Also, where parties are at liberty to bring on record their respective written arguments. If so desired. Also, registry to list this matter again on 17/1/2025 for delivery of orders. Madam, by slip भेज दीजिए 17 को इसको लिस्टिंग करा दीजिए. हमको एक बार यहाँ से इंटीमेट कर देने चाहिए, हम ऑनलाइन आके इसको डिलीवर करेगा. बे फाइल मेरे पास है, अब बाय स्लिप भेजिएगा. ठीक है?
Obliged, Your Lordship.
Just indicate the judgments, paragraphs,
Yeah.
and your submissions. That's
Okay.
all. Mr. Tapo, you
Yes,
also
yes.
give me,
Okay.
because interesting.
May I please, Lordship? Lordship, the petitioner appeared and recorded his statement as your Lordship directed.
So we have received the case diary, Lordship.
Hmm.
The thing is, Lordship, the IO, Lordship, he have recorded the statement of the Lordship accused in the wrong provision. They say he should have recorded under 181 of BNSS, but he recorded under 23(2) BNS.
He'll appear once more.
Yes, Lordship.
Heard Mr. P.J. Das, Learned Counsel for the applicant, also heard Miss. Anything requiring his custodial interrogation.
Nothing else, Lordship.
Then we'll ask him, we'll clear him up, we'll ask him to go, but
Yes,
he will
Lordship.
appear.
Again, Lordship, 121 under
Wow.
BNS.
You appear once more. We are giving you absolute. Order is being made absolute, but you appear.
Lordship, one more chance, because the status report has not been served, it's also not been attached, Lordship.
This has not come.
No,
What
no,
is
incomplete, Lordship, actually. Because as per the Lordship case study, Lordship, I have go through, Lordship. Actually, they have this several, Lordship. FI was there against
Okay.
him, Lordship.
Heard Mr. P.J. Das, Learned Counsel for the applicant, and also heard Ms. L. Hage, Learned additional public prosecutor appearing for the state. So, it is submitted, the case diary has been produced, and on perusal of the same, it is revealed that the accused in terms of the liberty direction so passed by this court wide order dated 4/10/2024 appeared before the investigating officer on 9/12/2024, and his statement has been recorded. So, however, it is seen that the statement has been so recorded under a wrong provision of law. So, be that as it may, the CD does not reveal the stage of investigation, and a report of the IU is not present therein. Also, accordingly, Ms. Hage is directed to receive a report, updated case diary with a report with regard to the stage of investigation of the matter. Also, registry, the petitioner shall again appear before the investigating officer on or before 31/12/2025 for further recording of his statement. Registry to list this matter again on 7/1/2025.
Well, some time may be given.
Why?
He's a very small shop owner, because it's very hard to manage to come all the way from Shivsagar to Arunachal Pradesh.
But
And
what difference does it create, Miss?
yes, my lord, because the statement is very clear.
It's a wrong recording of provision.
Yes, Lord.
Nalai,
Yes.
status report, appear to Nalai, appear ko काट दीजिए आप. Status report on 7/1/2025.
Yeah, man. I'm deeply aware.
Interim order passed earlier to continue till the next publication.
Lord.
Obliged.
I think we could have made it absolutely.
Yes, sir.
Yes.
Anyway, you have your.
Yes,
All right. In the office note dated 18/12/2024, service report on respondent number 2 is. The service upon respondent number 2 is not complete. Await service report upon respondent number 2 for further 3 more.
Your Honor, kindly allow us to take first step.
When did you?
Through the steam mode, and through jurisdictional police station and through registered prosecuting through PPO.
Madam, you have not taken through PP?
Not yet, Your Lordship.
No.
Oh. The learned counsel for the petitioner submits that he be permitted to take fresh steps through the office of the public prosecutor. Oh, no. Through your office?
Through the jurisdictional public.
Through the jurisdictional office, through the police station, by routing such notice through the office of the public prosecutor, Itanagar bench, Arunachal Pradesh. Itanagar bench, Guwahati High Court. Post steps be taken within 2 working days from today. Post Ms. L.T. Gini on the next date shall receive instructions with regard to the status of service of notice upon the respondent number 2 from the inspector officer in charge of the jurisdictional police station. Full stop. And apprise the court about the same. Full stop. Registered to list these matters after 4 weeks.
Your Honor, kindly allow us to take a step through the steam mode also.
Dusty.
Let us not make it a civil case.
Yes.
Please, Your Lordship. Lordship, here also I've seen that service is still awaited. I may be allowed to take fresh step, Your Lordship. And meantime, Your Lordship, I would like to draw Your Lordship kind attention. I have mistakenly written section 528 instead of 528. I have written it as 530. So I may be allowed to correct today before the
Mr. Swensel on a counsel for the petitioner submits that in the application, it has been 528, it should be.
It should be, Your Lordship, wrong.
Has been in the cost title, it has been on in the cost title, inadvertently, it has been shown, it has been written that the present application is so instituted under section 531 bracketed 2 bracketed A of the BNSS 2023. However, the same should have been section 528 of the BNSS 2023. So the praise that he be permitted to correct the said inadvertent error, so occasioning in the cost title of the present application.
As well as the Lordship in of this second page there also.
In the application, no, the only you make it here.
This one, Your Lord.
This one you make it. Synopsis is for us only. It's nothing. Prayer is not objected to by Mr. G. Tado, learned counsel appearing for the learned additional public prosecutor appearing for the state respondents. Full stop. The said error on consideration, this court permits Mr. So-and-so, learned counsel for the petitioner to correct the said error. Full stop. The present petition would now be considered, would be now considered to have been so instituted, invoking the provisions of section 528 of the BNSS 2023. Full stop. the petitioner shall within the next 3 working days file an amended cause title in the matter. Full stop. Seen subparagraph. Seen the office note dated 18/12/2024. Service upon the respondents number 2, 3, and 4 have not been completed. Full stop. Mr. Counsel for the petitioner submits that he be permitted to take steps upon the said respondents number 3, 4, and 5. 3, 4, 2, 3, and 4. 2, 3, and 4 through the jurisdictional officer in charge, through the jurisdictional police station. Also, prayer accepted. Petitioner to take steps for service of notice upon the respondent number 2, 3, and 4 through the jurisdictional police station by routing the same through the office of the public prosecutor, Itanagar Bench, Guwahati High Court. Steps within 3 days from today. Also, on the next date of listing, Mr. Taro shall, additional PP, shall receive instructions and apprise this court about the status of service of notice upon the respondents number 2, 3, and 4. Raised it to list this matter again after 4 weeks on a date to be fixed by. Yes, Mr.
Please, Your Lordship.
Yes.
In the last hearing, appeal has been admitted, sir. And the Honorable Court also directed deposit from certain amount. That will go to it, my lord. Your Lordship may now. Actually, the facts of the case is that, my lord, Ministry of Defence, the Union of India, they have acquired 357 acres of land. And after the acquisition, the 100% payment was made. That is nearly about the 70 crore. And by that time, as per the notification issued by the government of Arunachal Pradesh, 150 rupees per square, as per the notification 2022. 150 rupees was paid, accordingly nearly 70 crores have been paid. And they were without any protest, they were satisfied. They have given willingness certificate.
The reference case records are here.
Yes, they have
right. Affidavits have been filed.
My lord, as far as the daily is concerned, it's not yet filed. Because of what has happened, in fact, my lord, the state has also, today these are coming up, the state has also filed an appeal against the same judge.
Where is it?
Today it was mentioned, my lord, and I have got the receipt copies today only.
And there is another appeal filed by you.
By the collector. The
Collector.
Revenue department.
So my humble prayer is
All together?
No, all together, my lord. Actually, the humble prayer is the award may be state, my lord. Till the next hearing of the case.
Allow the unlisted mention taken up along together. Take 2 months.
Mr. Doloi may have to go.
No.
Will be
He is uncomfortable, my lord.
It's 1 o'clock only. Okay, 2. Yes, what do you have to say? Everybody is against you. All have filed appeals. There is something there that means. And you have not filed an objection.
My lord, because the other 2 appeals I have received copy only today, my lord.
No,
I have to go
that have not been gone.
My lord.
But the one which has now attained the first birthday, why you have not filed
The
a...
other day, actually, I have submitted, my lord. This, what has happened is that this particular
No.
case is based on.
No.
this
Do you
revision
want
of
to?
rates.
Do you want to file an objection or you are
Yes.
ready to hear? We'll hear, Mr. Doloi. No
No,
problem.
we have to, my lord. Then because they were proposing to file appeals, we were awaiting that, my lord, because their grounds also has to be seen and considered, my lord, as to what are the things they have asked.
They'll have.
And on the other day, actually, what I faced is that the stay, my lord, has to be conditional in the money decree. And the judgment that is written by the trial court here is actually born out of another judgment in which rates have been revised in Arunachal. That matter is pending in the Supreme Court. Supreme Court has asked.
No, what conditional order should I pass here?
The Supreme Court has said in the same matter of revision of rates, 2012 rates have been updated and the rates have been revised. So
that case, 2012 rates, then 15 or something, it was revised.
2022, right?
So that revision, that is in the Supreme
Supreme Court as of now, but then Supreme Court has said 50% you pay as of now, and then we will hear it on merits. So that matter is coming up on 17th of January.
Yes, there are serious issues being raised here. Whether this is same issues raised there or not, I don't know.
Now, as far as the power of attorney is concerned, the issue is different, but then the other issues are the same. As far as the multiplication factor and rate factor.
We have a behind Mr. Doloy on that point in one case.
Yes. The power of
Mr.
attorney.
Doloy gave up that argument, so we did not.
No, subsequently I adopted my note because I understood, Honorable Justice understood judgment later I read it. Your Lordship has enlightened.
As far as the power of attorney is concerned, we have filed an additional affidavit.
There is a decision. And Mr. Doloy will be relying on that.
Yes.
So I think this is a case.
Judgment is
That plays before the trial court. The trial court has considered that as.
No. We. In another case, I could not decide that on that point because by the time it was true,
It was on a.
I was not coming here, they were facing this, so I had to release it. But we had gone deep into that issue. Mr. Senior Counsel, Mr. D. Das had made his arguments.
Actually, that
He had raised that point. Then Mr. D. Das has made his arguments, convincing as always. Then I got another decision. And there was one.
Our High Court judgment is also there. Justice
Patna. Okay, Mr. We'll have it at 2.
My lord, if we take it 2, meanwhile, I'll give the.
That same one.
Yeah, this case, my lord, this case. That judgment is also there, man.
Allahabad, yes.
Allahabad.
Allahabad.
By Justice Chandrasud Bhai.
That was placed before the trial court, madam. We had argued.
Now, is there any Supreme Court decision on that?
No, madam. The Supreme Court otherwise says that a power of attorney holder can depose and appear, but then his deposition has to be only to the extent knowledge he has about the matter. He cannot stand in place of the principal and come and depose. So from that perspective, whether the
Okay,
jury
we'll have it at 2.
CPC, the other
Baki
appeals
files.
will also come.
Baki appeals, then we will see. 2 o'clock we'll consider.
We have Lordship, just spoken to this legal aid counsel Lordship. She is not present today, Lordship. So
Okay.
maybe later after 2 weeks, Lordship.
On the prayer made on behalf of Miss
Bingham.
Legal Aid Council for an adjournment in the matter today, registered to list this matter again after 4 weeks on a date to a fixed life.
Much obliged, Lordship.
Hearing matters other than item number 20 and 21, any urgency? When the 16, 17, 18, any urgency, Mr. Dickey, any urgency? Or we can have it immediately on reopening? 17 and 18.
18 is a matter of conviction, matter of decision.
We'll have it immediately on reopening.
17.
So when do you want it?
Can I have a fixed date, madam?
Yeah, we'll have it. 17, Mr. 17 RSA. Because I'll be leaving tomorrow, so it may be difficult.
Let it be on after vacation.
After any day,
Probably, let it be on February.
February.
Yes.
As prayed for by the Learned Council for the parties, item number 17. Registered to list this matter for hearing in the week commencing from 3 to 2025. And when do you want it, Mr. Dickey?
24.
On the prayer of the parties, Learned Council for the parties, item number 18. Registered to list this matter again on 21/1/2025 for hearing. 2021 we will be taking up, Mr. Katak is there. 16,
Yes, madam.
that your matter.
Yes, madam.
Just give me that file of 16. Mr. 2 minutes.
Yes.
This will take up. This will take up. This we have already heard.
Yes, madam.
It's only the final.
Yes.
That selection matter, we'll take it up. Yes. 15. 14.
So Ministry of Defense according to sanction for 537 acres of land and one village on the basis of market.
Please. Two IAs have been filed.
My lord.
257 is for
For additional documents.
This is the submission of some,
addition.
bringing some documents on records.
And 231 is the interlocutory application for stay.
For stay.
Okay. ISC 231 AP 2024. Heard Mr. Y. Dole, Learned Counsel for the appellant, applicant, and Mr. B. Pathak, Learned Counsel appearing for the opposite party, the respondents, opposite parties number 1, 2,
103.
no, 1 onwards.
1 onwards. So
103. Full stop. Issue notice returnable on, give a fixed date, early.
I know, let it be on the end of January.
Okay.
There's some marriage in the family.
Huh?
So
There's
let
some
it
marriage
be
in his
48th of
family.
January.
When?
30.
Huh? On 3/01/2025. Full stop. Mr. Pathak submits, Mr. Pathak, the Learned Counsel for the respondent is granted, is at liberty to bring on record his objections to the prayer so made by the applicant in the interlocutory application. Full stop. The same, this interlocutory application shall be considered on the returnable date how much will you deposit?
My lord, deposit question is before that, my lord, I have to go
No,
for.
if that is there, I can immediately do it.
My lord, actually what happened, this calculation factor, as Mr. Pathak has submitted, if it comes to 250 crores, not 450
Okay,
crores.
then we'll not pass it. ISC में लिखना, list again on ISC 257 EP 2024, list along with LA 03 AP 2024 on 31/2025. Okay? Now,
Additional documents, my lord, because anyhow it has to be considered only at the final
fine,
hearing.
that we
Because of Ibrahimuddin's husband, my lord.
consider it.
My lord.
And in this appeal filed by state,
My lord, there is only one thing, my lord.
what?
One thing, my lord, in the appeal filed by the state, my lord, there is some complication. The Guwahati High Court, my lord, Justice Mehdi had recently passed a judgment in which it is said that the deputy commissioner is not a person aggrieved and therefore he cannot file a land acquisition.
That you take up a.
So at this stage, it may not be admitted, only notice may be issued.
No, one is filed by the state. State one can be, it'll be.
The same thing, my lord. The proposition that has been laid down here is that the person aggrieved would be the person who is now required to pay. The state has no duty in paying as of now what has been awarded. Therefore, the deputy commissioner or any other party are not therefore persons aggrieved, and only the requisitioning authority who has to pay will be a person.
D. Suki, Learned Counsel for the appellant. Full stop. Also heard Mr. B. Pathak, Learned Counsel appearing for the respondent's number.
It was same, my lord, I think.
Modi is the formal party, but otherwise it's still 103. Up to 103.
For respondents number 1 to 103. Mr. Dolo, you will be appearing for the Defense, Ministry of Defense?
Yes, Minister of Defense.
Mr. Y. Dole has entered appearance on behalf of the respondents number 104, 105, 106, and 107. So issue notice returnable on 30/1/2025. Full stop. Here we go. Appeal 1/2024 से second paragraph को quote कर लीजिएगा. हाँ? Appeal number 1/2024 से second paragraph को quote कर लीजिएगा. There is no interlocutory application here. No. Then one more appeal.
One by the deputy commissioner, one by the
This is
revenue.
by deputy commissioner. So the question of maintainability of the present LA appeal raised by the learned counsel for the raised by Mr. B. Pathak is kept open for consideration in the matter. So, ये भी heard Mr. You are appearing, Mr. Suki?
No, ma'am. Again, but I'm appearing, Your Honor.
Your name?
M. Ansari, Murtaza Ansari.
M. Hassan, learned counsel for the
Ansari.
Ansari. M. Ansari, learned counsel for the appellant. Also heard Mr. P. Pathak, learned counsel appearing for the respondents number 1, for all the respondents. For all the respondents. Full stop.
Serial number.
You see, no, you see from the top only. Class 5, class 4, class 8, class 9, class 4, class 4, class 10, 2 class 10, then nil. He does not even have a qualification. All appointed.
Lordship, they are operator. They are skilled in
Where,
something.
where, why have you put them together then? You should have put them in a different bottle altogether. And here in this list, now you have made this list at page 17.
Page 17, Lordship.
That 18, sorry.
No.
18 list you have made. Huh? Here you have said operator, assistant operator,
Yes.
skill labor, skill driver. But here in this amalgamated list in the record that you have produced,
Yes.
it's only skill.
Skill is just
Skilled and unskilled. That's all.
Lordship, yes.
So,
Skill is
show me
Lordship, according to the pay, Lordship, unskilled, they got around the first pay of 1,200 something at that point of time. Now, when they become skilled, Lordship, they get around 15.
Petition is skill.
Yes, 1,500 something. For that, after some time, they are made skilled laborers, sir, because their work is hard, Lordship. Usually, they are not kept for unskilled for long time, Lordship. Just to, Lordship, let them get that enhancement of pay. They are being given the skilled, Lordship. And Lordship, in the original record, another blue flag, Lordship, there, Lordship may kindly see that one. Other than the panel list, another blue flag, Lordship. Maybe because it is 2012-13, we couldn't get much more than that, but then it can be seen that some documents were asked from there, some documents didn't reach them. Another blue flag, Lordship.
Now we've seen. Where is the speaking order in pursuance to directions passed by this court in the earlier round of litigation?
That's in my.
Any speaking order passed?
Yes, ma'am.
Page 26. But Mr. One thing,
Madam.
you approached the authorities after 3 years by your representation in 2016-17, right?
Yes.
But by the time these people have already been appointed and were working.
That is true, my lord. That is true. Since, my lord, I have spent a lot of time in this obtaining all these documents, my lord. Throughout the day only I could obtain all these documents, my lord.
Lordship, even my instructions, the officer says he never approached them, and even if there is any problem, he directly goes to the chief engineer, whereas he is under JEA.
That is the reason why he has been.
AE is there.
Madam, that is the reason why he is not been given.
Executive is there. And he was never
he was still a casual, skilled labor.
I am still
skilled labor.
Skilled labor, my lord.
Is this process still on for bringing them into work charge?
Yes. Not from that point of time, but he can be considered now on sympathy ground also, and then because.
Consider.
Yes, Lordship, that can be. Only he shouldn't ask for.
But he cannot ask for.
Yes, he doesn't have any right also, and that his performance also, Lordship can see the report is.
We have seen
always
that was the thing which stopped us. Otherwise, I'm going in his favor only.
My lord, in fact, my lord, I have placed some judgment in the earlier opinion also, my lord. We have this argued laws in this matter, my lord, in earlier occasion also, my lord. Then I have placed some judgments.
What is the argument?
My lord, my judgment, in fact, it was the, since my lord, they are alleging that I am not.
No, they are not. Forget that. Forget
my
madam's allegations. Just ignore that.
lord. My lord, from the.
Now tell me.
Yes, madam.
This is only a work charge upgradation.
Yes, madam.
This court during the last round of litigation did not direct that you should be given from a retrospective date.
That is true.
It only said the wordings are very clear. Your grievance was, I have been promoted, some juniors have been upgraded, but you have not been upgraded and your representations are not attended to.
Yes, madam.
Now you have come up making a challenge to the disposal order.
Yes, madam.
So the disposal order,
Not under challenge.
At page
Huh?
26, madam.
Disposal order is not under challenge.
a disposal order is not under challenge. Only the promotions are under challenge.
Yes.
Okay, fine, no problem. So did you challenge this private respondent's promotion during the last round of litigation?
In the last round of litigation, my lord, I do not have idea because I did not conduct that case, my lord.
So where that order sheet also is how it does not reveal. So if you have not challenged it at that point of time, how can you now challenge it?
My lord, the petitioner might have challenged because it's from the order, my lord, what we can gather from the second para of the order, my lord, passed in WPC 2000.
Here only the representation disposal was called for.
It says, my lord, the second para says the petitioner grievances that although he is working.
देख सकता है क्या यहाँ पे? 204 AP 2018. Parties.
He is working as casual labor for more.
Mr. Kamdok, if you agree, I can dispose of this matter.
My lord.
I'm not going to interfere with what has happened in 2013 today. 10 years those people are working. That if you want, if you can make a prayer to that effect, that your case is to be considered, I'll make observations and see to that they do it.
Yes, my lord. That, my lord, of course, I do not want to disturb the appointment of the private respondent.
But it will be prospective, not retrospective.
Within this certain.
No, that time we will give you.
My lord. Yes.
But your regularization will be from that date only, not from 2013. You agree to that? I'll pass the order now.
My lord, that order.
I'll record your submission.
Yes, ma'am.
Also, the present heard Mr. D. Kamduk, learned counsel for the petitioner, and Ms. MS Etik, learned additional senior government advocate, appearing for the respondents number 1, 2, 3, 4, 5, 5 and 12. 5, 1, 2, 3, 4, 5 and 12.
Oh, yes, yes.
Also heard Mr. L. Prame, learned counsel, appearing for the respondents number 6, 7, 8, 9, 10 and 11. Also, the present writ petition has been instituted by the petitioner hearing, presenting a challenge to the upgradation of the services of the private respondents number 10 and 11 were directly appointed as work charge employees.
Yes, ma'am.
Yes.
Upgradation of the services of the respondent number 6, 7, 8 and 9 as work charge category employees in the year 2013, as well as the engagement of the respondent number 10 and 11 hearing as work charge employees in the year 2000. When was they engaged?
I think 14.
2013, madam.
No.
10 and 11, not 2013.
Okay, this, my lord,
They are from different circle also, not in the list also.
10 and 11.
Not in the panel list also.
They were directly.
Yes, yes. In the year
And
2011.
the appointment effected in case of the respondents number 10
10 and 11.
and 11 as work charge Khalasi employees in the year 2014 and 15.
Yes.
2015 and 14 respectively.
Yes.
Also, the petitioner in the writ petition has projected that although he was within the zone of consideration on account of being engaged as a skilled master role, it's a master role or casual employee, as a skilled casual employee under the Pasigat EM division, Department of Hydropower Development, the DPC selection committee in its meetings did not proceed to consider the case of the petitioner hearing for upgradation while extending such consideration in respect of the respondents number 6, 7, 8, and 9. Also, it is further submitted that the respondents number 10 and 11, who were not working as casual employees skilled, were also favored with appointment orders, and accordingly, the petitioner, in spite of having rendered service in the service in the department since 2001, his case was he was discriminated against in the matter and came to be superseded by his by persons admittedly who were junior to him junior to him reckoning their individual dates of engagement. Also, the respondents by filing affidavits have contended that the case of the petitioner was not so considered on account of the fact that he did not possess qualifying criteria for the post of WC Khalasi and had not exhibited good and satisfactory performance during the period which was so reckoned for the purpose of upgrading casual staff skilled to the posts of work posts in the work charge establishment. Also, the respondents have also projected that there were adverse remarks existing against the petitioner, so given with regard to his performance by his superior officers, by the authorities under whom he was so discharging his duties as a skilled casual staff. Also, Ms. Ete, accordingly, it was projected in the affidavit that for the reasons so found against the for the reasons so stated and the reasons so stated, the case of the petitioner was not found suitable for upgradation as a work charge employee along with that of the respondents number 6, 7, 8, and 9. Also, accordingly, it is submitted that it is projected by the respondents in their affidavits that the present writ petition is called to be dismissed. So the above position was, however, disputed by Mr. Kamrup, learned counsel appearing for the petitioner, and he has submitted that there was nothing adverse against the petitioner brought to his there was nothing adverse existing in his service records which would have necessitated denial to him of the upgradation to the post of work charge employee. Also, at this stage, Mr. Kamduk submits that on account of the fact that the respondents number 6, 7, 8, and 9 were upgraded as work charge employees way back in the year 2013 and have been continuously serving against the set in such capacity thereafter, he would not press for the interference of their such appointment. However, he prays. First, with regard to the appointment of the respondent number 10 and 11, Mr. Kamduk submits that the said appointments were for a limited period of time. However, they were also continued in the work charge establishment till date. Mr. Kamduk, by further highlighting that the petitioner has been rendering his services as a casual skilled labor since 2001 on a meager salary, and he having been already deprived of the scale of pay that is attached to the post in a work charge establishment, submits that in the event the respondents, at least even with prospective effect, considers the case of the petitioner for upgradation as a work charge employee in the work charge establishment, he would give up the challenge made in the present proceedings to the appointment of the private respondents as work charge employees. So responding to the said submission, Ms. Ete, learned counsel for the additional senior government advocate, has submitted that the respondents would be agreeable to extend a consideration to the petitioner hearing for his upgradation to the post of to a work charge post with prospective effect. Full stop. Okay, ma'am, that much I can record. In view of the above submissions made by the learned counsel for the parties, this court is of the considered view that the present petition need not be detained further. Also, the respondents are now directed to consider the case of the petitioner for engagement for appointment against a post in the work charge establishment, and on such consideration being made by also noticing that the petitioner was in service of the department on casual basis since the year 2001 and during the year 2013, the petitioner's case admittedly reflected from the records was not considered in the manner required, the respondent's authorities, more specifically the superintendent.
Yes, my lord.
More specifically, the respondent number 1 and 2. 1, 2, and 3.
Lordship, here, I'm sorry for interference,
Ah.
Lordship, but Lordship, since he has left this circle now.
Okay, we'll ask the chief engineer. Chief engineer to do.
My lord,
We have gone to Allah, so the.
No, we'll ask the chief engineer.
Thank
We'll
you,
ask the
sir.
chief engineer.
Lordship,
क्या लिखा है? We direct the respondent authorities, more particularly the respondent number 1, that is the Chief Engineer, Department of Hydropower Development, Hydropower Development, Government of Arunachal Pradesh, to have the case of the petitioner considered for upgradation against a vacant post, against a post in the work charge establishment in the circle he is currently posted, right?
Yes, ma'am.
In the circle he is currently posted, and or in any other circle wherein such vacant post of work charge in the work charge establishment suitable for engagement of the upgradation of the services of the petitioner is available. The said exercise shall be initiated and concluded by the authorities within a period of 3 months from the date of receipt of a certified copy. Post up. The petitioner on his engagement as a work charge employee shall be authorized a scale of pay as now being enjoyed by the private respondents herein. However, the petitioner would be so fixed in the said scale, considering him to be an appointee of the date on which such order of appointment is so issued to him. So you will start from the initial stage.
My lord, my information is that, my lord, in fact, after the pending of this writ petition, my lord, the authority are saying that although the vacancy is available in the department, since you have filed a writ petition before the court, let the order come, my lord.
No,
otherwise, the post is available, my lord. So therefore, my prayer, my lord, my request would be that, my lord, let the exercise complete within a month, my lord. Within a month, my lord.
Why? Why again you will have to come on content?
Official things, it takes time.
Let him, the chief engineer has to tell the superintending engineer. Superintending engineer will then tell the executive engineer. Then the AE will give the report. So thinking about that, I said 3 months.
One more thing, just it may be mentioned lots of concerned chief engineer. There are 4 chief engineers.
Concerned
here-
chief engineer.
Yes.
Concerned chief engineer. Department of so and so. Under in whose establishment the petitioner, in whose establishment the petitioner is, in whose organization the petitioner is so engaged as a casual / skilled employee. I'll correct it.
Much obliged.
It cannot be done within 1 month, my lord. My prayer would be
2 months.
2 months, my lord.
2 months.
Because, my lord,
2 months. 2 months.
my lord,
2 months.
my lord.
2 months.
Yes. Not obliged, my lord.
Madam, your records you can take.
Yes. Much obliged. This
Hello, this disposal हो गया, order दे दिया, मैडम को टाइप करके देने से, लेकिन आज हो सके तो दीजिए, कल हम निकल पाओ.
Much obliged.
Because Mr. Kamduk, if we go deep into the matter, we'll also have to consider the stand of Ms. Ete, that your services at that point of time, and it's very badly written, and you have not filed a counter to that.
My lord, yes, of course, my lord. But my lord, that should not be the reason for
that can be a reason. That for the post that you are holding,
yes, my lord.
that can be a valid reason. Morning, that day I was thinking that, let me see if that is the reason, I'll have to go into that.
My lord.
If I have to dismiss your petition.
My lord.
But I was not in a...
My lord may agree.
It did not give me a wife to dismiss it.
My lord may not agree with me or not, my lord. My lord, otherwise, my lord, I was having a judgment, my lord, where it says, my lord, uncommunicated adverse remark should...
Mister, you are not a government employee.
My lord.
You are a casual employee.
My lord.
So that findings is only to the purpose of, it need not be communicated to you. There is no law of that. You get my point? It's not adverse. It is your performance report. If they find a man to be not performing as required, they can supersede him and get another man. Because here you see, tomorrow by when you go for regularization,
Yes, sir.
then it would be a different ball game altogether. Even they are there, tomorrow a regularization happens, your case will have to be considered, taking you from 2020. Why 20 years they have completed regularization under your that act?
So many are there. In other department also some are 25 years at least. Yes. Yes.
Much obliged.
We considered.
Hmm. ठीक है 17-18 तो adjourn हो गया 17-18 adjourn. Yes. Is it ready? Sir, the records have come?
Yes.
Where? Tricol record I gave us.
20 and 21.
Yes.
20 and 21. We are in the. We are in the. We are the petitioner.
Yes.
We are present in.
Yes. What do you want to show me from here?
This annexure J madam of original complaint.
Just a moment. D.
J.
No, D is the sending of the sample.
Yes.
Then
madam, that has been communicated to the madam original company on 13 madam.
10.
Yes. 13/10/2017. madam. Thereafter, madam, there was no madam communication. Finally, madam, again, as per the section 18, the inquiry has to be conducted, madam. And thereafter, again, madam, another letter, 5th February 2018 is the last correspondence, madam, regarding that aspect, madam. With reference to your letter number so and so, it was intimated that your firm receives the page, madam. I'm reading original complaint of 77, madam. Page 39, madam.
Huh?
39, page number 39. Annexure L, page number 39.
Annexure
L for madam. Received a memo on this issue, NSQ letter 2 from the government of West Bengal, and the mentions that you director, they provided reply of all particulars in the due course of time to so and so under intimations to this office, but till date no reply received from your side. So please forward the reply action taken from the Directorate of the Control Drugs Control Government of West Bengal in this matter. As per the provisions of section 23(4), 3 and 25(3) of the Drugs and Cosmetic Act 1940 and the rules.
So you had already sent it in on 13/10.
Yes, ma'am.
Why are you again sending it on 5?
This is something like another giving opportunity, madam.
No. From where did you get this sample? The sample is already sent.
This is.
You come to page 35.
35 is the letter sent to the captive the petitioner company, madam. This is the second reminder letter sent.
I know. First letter itself, you had given them the test report and the. Okay. One seal.
Yes.
Sample you have given.
Yes, madam.
Then what happened?
Thereafter, final the communications lordship perused we sought for the details from the petitioner company. Annexure, same complaint, page number 43, annexure N series. This is the procedure required under the provisions. Last letter, Page number 43, I'm reading, To company, the MS so and so, the subject, the draft reports to be of not.
You have a copy of this complaint with you?
Yes, ma'am.
You have a copy?
Yes.
Can you give me a copy? I don't want to carry this.
Madam.
You can give me a copy.
And madam, details we sought for from the petitioner company is first reference letter, madam. Forwarded to you letter number so and so, number 1, reference, number 2, number 3. These are the copies, madam, we sought for from the company. And this copy has been finally furnished to the department is at page number 45, madam.
And thereafter the department had taken action.
Yes, ma'am. Before furnishing of all these documents, madam, we cannot initiate, madam. And this is of 2000, madam, letter dated, which we have received 21 December 2018, madam. Thereafter, madam, we initiated and of course, madam, in
Delay.
drafting, madam, there is a delay.
That delay, can it be condoned?
Madam. However, madam, as per the provisions, madam, this 27B, if punishment is 1 year to the extent of madam,
Taking cognizance is 3 years.
madam.
So this is within 3 years.
3 years. We filed on 5th September.
So you give me a copy of this.
Madam.
I will not carry this. Anything else to be looked into here?
That is the only madam, documents.
This is the only thing.
And that documents are not available in the present criminal petition, madam, 15 and 16. Admittedly, madam, there is a delay in madam, that part we have already admitted.
Okay. The file. This court had wide order dated 17/12/2024 requisition the records of the original complaint case number 77 of 2019 from the court of the learned CJ Capital Complex UPN. The same has been received and perused by this court, whose registry is directed to send back the records of so and so to the learned trial court forthwith. इसको कभी इतनी रजिस्ट्री को ये ऑर्डर को कॉपी देके बोल देना कि इनको भेज देगा वापस जहाँ से है वहाँ पर जाएगा दिस मच वो फाइल मेरे पास रहेगा Mr. Bachcha, anything more to add? We are closing.
My lord. My lord, yes. Yes, my lord.
You will get it back when I... But you will not get the judgment before 2nd or 3rd week because I am going back to Guwahati and we'll be on vacations. So
Yes.
by 2nd week you can expect, or latest by the 3rd week you will get it. This much liberty I am taking.
Yes, madam.
With the parties have been heard at length. Same order. Parties have been heard at length. Hearing concluded, judgment reserved.
Deep level.
See. Okay.
Last item. Yeah.
Huh?
This is the last item.
Oh, last item. Thank you.
Yes.